But doesn't this open up kind of Pandora's box for, more conservative, less environmentally concerned states and cities to release raw sewage across the board, not just when there's excess stormwater, et cetera?
Yeah, I think that's right. You're right in that San Francisco is a kind of unique plaintiff to be leading this kind of case that's challenging environmental regulation. But you might not be surprised to learn that they were supported in their challenge by a number of very powerful industrial trade groups.
Hey, it's Jordan. I am in Flint, Michigan, East Palestine, Ohio, Tumwa, Iowa. Please support the only independent outlet on the ground covering what the corporate media covers up.
Hey, it's Jordan. Delighted to be joined by Emily Miller. You are an attorney with the Food and Water Watch that does great advocacy work. I know there is just 24/7 chaos right now that everyone else is experiencing in the Trump administration. But I thought it was important to talk to you because I think water is relatively important to all people. And this news came out last week, kind of got lost in the shuffle. The Supreme Court, in a 5-4 ruling, ruled that essentially cities can discharge more raw sewage into water supplies. Part of raw sewage would be human waste, as in poop, among other things. And we cover water extensively. Obviously, you monitor water extensively. So first, could you kind of explain for the layman, because this has to do with the Clean Water Act, among other things, what does this ruling allow and why is it dangerous?
Yeah, so this case is the latest in a string of legal victories that have been chipping away at our bedrock environmental laws, like the Clean Water Act, by stripping agencies of their power to regulate polluters. So the decision really showcases this Supreme Court's open hostility to clean water protection, but it also makes it harder for EPA and state permitting agencies to protect water quality as federal law requires, because it takes away an important tool that regulators have routinely used to ensure water quality protection. So the lawsuit focused on the question of what authority EPA and state regulators have under the Clean Water Act to make sure polluters aren't violating water quality standards. So essentially, what can EPA do in situations in which polluters are degrading water quality to such an extent that water bodies become unfit for certain public uses like drinking water and recreation? And like you said, the specific facts of this case have to do with sewage and particularly the city of San Francisco's sewer system, but it has broader implications beyond the specific facts at issue. Though those are, of course, worth mentioning because they're particularly nasty in this case. It dealt with the city of San Francisco's sewer system, and situations in which heavy rains kind of overwhelm the city's sewer lines, which receive both sewage as well as stormwater runoff. And what ends up then happening is that the city inadvertently dumps a whole bunch of untreated raw sewage into the Pacific Ocean. So before the decision came down, what EPA would do is they would impose water quality-based restrictions on polluters like San Francisco in their Clean Water Act permits. And if they had enough information, they would try to be as specific as possible to impose specific best management practices or operational controls that told the city or other polluters exactly what they needed to do to achieve certain water quality results. But that information was not always available to EPA. So in those situations, what they would do is they would impose what the court is calling end result requirements. So more generic prohibitions against the polluter, prohibiting them from violating water quality standards. And regulators often have used this kind of catch-all approach in all sorts of situations, but particularly when they're dealing with municipal sewer systems, because those systems include they deal with a complex and changing mix of domestic sewage and commercial wastewater and runoff, the exact composition of which is really difficult to predict. So as a result of this decision, regulators can no longer use these generic end result requirements in a polluter's Clean Water Act permit. Now, what they have to do is they have to come up with individualized and very specific requirements that, if implemented, will achieve the desired water quality result. So in practice, it makes it much more difficult and time-consuming and expensive for a regulator to actually issue a protective permit.
So in a simple way, the lawsuit that went to the Supreme Court by San Francisco seemed to be about a very specific thing, which was excess stormwater, floodwater, and the ability to discharge that. But now this Supreme Court ruling is not just about excess flood or stormwater. Doesn't this now, pun intended, open up the floodgates for less environmentally conscious? You think San Francisco, you would think city, liberal, care about the environment, but doesn't this open up kind of Pandora's box for, more conservative, less environmentally concerned states and cities to release raw sewage across the board, not just when there's excess stormwater, et cetera?
Yeah, I think that's right. I will clarify, the ruling doesn't say San Francisco, release as much raw sewage as you want. It just makes it more difficult for EPA to deal with that inevitable situation. But yes, you're right in that San Francisco is a kind of unique plaintiff to be leading this kind of case that's challenging environmental regulation. But you might not be surprised to learn that they were supported in their challenge by a number of very powerful industrial trade groups representing mining interests, fossil fuels, industrial agriculture, all of which, of course, stand to benefit from a ruling like this, which weakens environmental regulation across the board. And San Francisco, the way that they argued this case, they threw everything at the wall and tried to see what would stick. So they argued specific things about their permit and the conditions in it. They also argued more generally that the federal law doesn't give EPA this authority to regulate them in this way. And that's what the court latched onto as a way to further chip away and strip away EPA's powers to regulate polluters.
And isn't this kind of a double whammy for those that don't remember? Because the Supreme Court last year had a ruling that severely weakened agencies across the board and their ability to regulate. So the Supreme Court has already kind of removed a lot of the teeth of agencies, and now you're making it even more difficult for the EPA to regulate this.
Yeah, you're exactly right. Last Supreme Court term in June of 2024, they came out with a decision called Loper-Bright, which essentially says this long-held deference that we've shown to agencies' legal interpretations of statutes that they administer, we're getting rid of that. We don't care what the agency thinks. We're going to just interpret the statute the way we think it should be interpreted and not defer to agencies. And that really did open the door for now the court to kind of run roughshod over environmental laws and interpret them in any way as they see fit, which is on display in this case.
Right. And, for lack of a better phrasing, hate to be crass, doesn't this run the risk of like poop in the water or human excrement? I mean, there's other things in raw sewage, but that is part of raw sewage.
Yes, the record in this case went through a number of documented instances of raw sewage, including scum, floatables, toilet paper, poop, like you're saying, kind of making its way onto popular recreational areas, local beaches. And, for you think about the Pacific Ocean as a huge body of water. So just how much raw sewage does the city have to be releasing in order to have that kind of measurable impact on water quality is pretty astounding to think about.
I'd like to ask you broader. Obviously, Food and Water Watch is focused on food and water, but something that's troubling to me is a lot of these decisions, and it's not surprising, obviously the court has become very ideological, conservative. They have no expertise to make these decisions. I mean, in the case of Roe v. Wade, infamously, some of the white conservative judges had to be corrected by a lawyer because they were confusing, the female menstrual cycle, right? They don't know. Mm-hmm. In this case, their ruling, they were kind of determining that the EPA's regulations were vague, but these are not like scientists or engineers on the Supreme Court. they don't have any expertise. That's why you allow experts in agencies to regulate. Can you kind of talk about the Supreme Court seems to be making a lot of decisions where they don't have the proper expertise to be ruling in these ways that jeopardize health?
Yeah, I mean, and that's one of the consequences of moving away from agency deference. That the principle of agency deference was created decades ago with that understanding in mind, that agencies are made up of a number of experts with scientific and technical knowledge, and they are in the best position to really understand the laws that they are tasked with administering and fleshing them out. That is no longer the law of the land. And what we see happening more and more, and what was on display in this case too, is that the court is really relying heavily on friend of the court briefs from industry players. Justice Alito, who wrote the majority opinion in this case, was consistently citing to these amicus briefs from these industry groups to back up his arguments and to kind of flesh out his understanding of the problem. So he's deferring to industry, and not EPA and the regulators who should be receiving that type of deference.
And also just talking about the current real-time chainsaw, for lack of a better phrase, Elon Musk with the chainsaw.
Mm-hmm.
I mean, they're cutting at the EPA too. So with this Supreme Court ruling, isn't it kind of a double-edged sword? They're firing a lot of EPA officials. The EPA, I mean, I've got a lot of criticisms of the EPA based on my reporting, and but they were already, in my opinion, understaffed, and now they're cutting and firing more people at the same time. This is won't this be a more time and labor intensive process now because of this court ruling, where you need more people because it's going to take longer to regulate?
Yes. Yeah. One of the frustrating things about this opinion is that the court sort of snidely remarks that, well, EPA is constantly touting its expertise to us in litigation, so it should be well equipped to figure this out and deal with this issue in a more specific and targeted way. And that just completely ignores the political reality of what's going on right now, which is that, like you're saying, EPA staff and resources are being gutted left and right, and they're becoming less and less capable as the days go on. And what the court has done is it just has taken away a critical backstop measure that EPA can put in place to protect water quality and protect the public from pollution.
Right. And while I have you here, I know this isn't the court necessarily, but Trump, when he came in and, did 2,000 executive orders in the first hour, part of that was reversing President Biden's administration's attempt to finally regulate these PFAS, which are the forever chemicals that cause all sorts of health problems, cancer, reproductive issues. Can you kind of talk about that? I know that's not up to it hasn't gone to the Supreme Court. I don't know if there are lawsuits against that, but I mean, in this case, we're talking about discharge of raw sewage into drinking water. But in that case, I mean, PFAS are a major issue all across the country. And that was Biden. That was the Biden administration proposing to regulate it for the first time. It wasn't actually being regulated. So now we've taken an even further step back.
Yeah, I don't know if there are any challenges to that particular order going on at the moment. But yes, I will say that PFAS has been a serious issue in our country for decades and has just been completely unregulated by the government for as long as they've been around. And only just in the past few years have regulators and lawmakers started to wake up to the kind of the serious health consequences of these very pervasive and ubiquitous chemical compounds, which they're called forever chemicals for a reason, because once they get into the environment, into our soil, into our food, into our water, they stay there. They don't break down. And the little progress that we've made in the past few years certainly is not enough. But it's disappointing to see that's being walked back.
Absolutely. You guys have a lot to contend with. You're probably understaffed and undermanned yourself. So now you got from poop in the water to PFAS, and not to mention all the crap in our food. So thank you, Emily Miller, staff attorney with Food and Water Watch. They do great work. So check out their website, and we'll stay in touch.
Thanks, Jordan. And yes, we are ready for the fight.